Yeah, please. With the consent of others, I beg to mention item number 1 and 2, Lordship. Lordship, these matters, Lordship has already heard apart. Can it be tomorrow, Lordship? Why? So I have some difficulty today.
Tomorrow.
The prayer, Mr. You. But tomorrow again difficult. Tomorrow more number of matters are there. Today it is easier, lesser matter.
On any date, Lordship, not
No, but
Except
once
the-
we start, we don't like to delay.
except today,
Because if
Lordship.
we hear it in part, we have to retain what we have argued.
Yes, Lordship.
It's difficult for us.
I can understand, but Lordship, my
So if
difficulty
you understand, you don't take the adjournment.
for the day, Lordship,
What is the overwhelming reason? Anyway, we are hearing Mr. Nath. Your part is already over.
no, Lordship, I have to make a reply, Lordship.
You give a reply whenever you want. Let Mr. Nath complete his argument. Let Mr. Nath complete his argument because he is in the middle of his argument. Your microphone is off.
Or if my lord pleases, let him come tomorrow.
No, we have difficulty, not about,
Lordship.
no, you are not
Lordship,
inconvenienced. Because moment we hear a
Yes,
matter in
Lordship.
part, we have to remember each and every argument
Yes,
you have made. Why should we keep it in our mind for a longer period of time?
Yes.
And what reply you intend to give?
Lordship, regarding basically para 97 and
No,
analogous.
another way, and we have already taken note of that. We have already argued it. Your other argument, we have already accepted it.
No,
Yeah.
Lordship had already heard.
Okay, anyway, item number 1, please continue.
Lordship.
As you were already here. Please continue. Yes, sir. Yes, any other mention?
But kindly accommodate it for 5 minutes, or one matter is there. 5 minutes, I'm just.
Well, let him
Lordship.
say he wants to argue something more. Yes, Mr. Dutta. One issue is see, after hearing for 6-7 days, it's very difficult to adjourn.
Lordship, in fact.
Whatever it is, please, what is your other issue you want to raise?
Other issue-
97, we have already heard you.
No,
What is other issue?
97 Lordship had already had other side. My only contention, I have expressed only my contention. Because Lordship has made a query whether 97, if the inquiry officer does not find the person concerned proceeding, then whether inquiry officer can submit the report or is it mandatory?
Yes, what is your submission?
Lordship, this is inquiry is mandatory, Lordship. Inquiry is mandatory, but provide my understanding is if the inquiry officer after repeated Lordship attempt, he could not press out the person and record whatever his statement, Lordship. In that even
And,
inquiry,
Mr. Dotto, in this context, what do you understand by inquiry? What do you understand by the concept inquiry when you say inquiry is mandatory? What are the requirements of an inquiry?
collecting basic material facts, because allegation.
This is what, that's why we are putting this question to you. See, these are proceedings where the authorities, Supreme Court has already accepted it, that the authorities are not expected to know anything about the nationality of a person. That is paragraph, I think, 26 of the Sarvananda Sonal second judgment. Supreme Court has already accepted this situation. In that context, suppose the authorities come across a person and they have some doubt in their mind that this person may be a citizen, may not be a citizen. So only inquiry they can do is to ask that person to come forward,
Yes, certainly.
give him the opportunity, what material you have.
Yeah.
if the person puts forth good material to substantiate his citizenship, authorities may take a call that no further proceeding is required in this case.
Yes.
Or if the materials produced is not good enough, authorities will refer it to the tribunal if they're not satisfied. Third situation is the person is not making himself available. They are unable to get hold of this person.
Yes.
So now the very view formed in the mind or that this person may be a foreigner, that itself is an inquiry. If the person is not available, not coming forward, that itself is an inquiry.
Yes, Lordship.
I
That-
think,
that- that-
I
that-
think
that would be my submission.
the question is very clear.
That would be my, what Muslim Mandal says, paragraph 96, Lordship, 97, attempts should be made. Therefore, and then-
Definitely, they make an attempt.
therefore, my submission would be, Lordship, inquiry is sine qua non. It is essential inquiry in any condition.
What is that expression you use? Sine qua non. What does it
No,
mean?
it is mandatory.
Mandatory.
It is mandatory. Without inquiry, Lordship, a reference.
No, now the question is, what is an inquiry? Inquiry is maybe of various types. Say in a disciplinary proceeding.
Yes.
Inquiry is a very elaborate procedure.
Yes.
Inquiry is also just the thought in the mind that what may be the underlying facts in this case.
Yes.
That is also an inquiry. So your issue is clarified from that extent.
Inquiry is required, Lordship, because on the basis of the materials, Lordship, whatever
Very well.
collected by the inquiry officer, Lordship, he has.
Any further submission?
Yes, Lordship. Basically, I would, Lordship, like to. My argument would be to safeguard what is the principles laid down in basically paragraph 97. Lordship, because 97, Lordship, is aware, Lordship, this is full bench judgment, Lordship, and this is binding on the division bench, Lordship, first of all. And
So are you raising the question of jurisdiction of a division bench?
no, Lordship,
If you raise, please raise it in a direct words, not in this indirect manner.
Lordship, I
If you
will.
raise, we'll answer it. If you say that this bench cannot take up the issue, please put it in more straightforward.
Lordship, I will explain. And
Okay.
secondly, Lordship, Lordship, Rina Rani. WBC. Yes. Lordship, the judgment delivered by one of the division bench of our High Court, Lordship. That is WPC number 2706/2000. May I read it? Lordship, paragraph 10. Thus, a proper pre-referral investigation is absolutely necessary to avoid such problems. Such a pre-referral investigation cannot be mechanical. There must be proper application of mind by the authority concerned, persons concerned in the locality, including the proposed proceeding must be examined whenever possible. The referral authority has to apply its
Okay,
mind.
which paragraph you were reading?
Paragraph 16, Lordship.
16. See, must be examined wherever possible. We are contemplating the situation where it is not possible, the man is running away.
No, that particular,
Mr. Doctor,
particular.
Mr. Doctor,
Lordship.
the very purpose of this hearing is what is to be done in a circumstance when the person is avoiding.
No, that.
So
that
don't please
particular
bring in
factual
the situation
circumstances
when
might-
he is cooperating. When he is cooperating, there is nothing to be decided. We are deciding when he is avoiding.
Lordship,
So suppose the man is avoiding,
Lordship.
this border police does not have the power to arrest him
Right.
because there is no CRPC is not applicable.
Yes,
Now, if the border police forcefully picks up this man, puts him in custody and then say, please answer, you will be the first one to raise an objection that without any authority, I have been detained. But at the same time, authority intends to make an inquiry. You are just avoiding the authority. You are running away. These are people who neither have much of an identity nor of a surety of their locality where they are available. It's not that the police knows that he will be available in X place. Let me go there and give him the opportunity. They are all people who are moving constantly all
Yes.
the time.
Yes.
If you put in this kind of stringent requirement, then this itself is an inhibition on the inquiry as well as the procedure to make a reference, because you will give a free license to that man. If the inquiring person is trying to look after you, only advise, run away. Nor the inquiry officer can take that man to custody. So where is the solution?
No, Lordship,
I know you are making some very strong submissions, but where is the solution? You give the
No,
solution.
Lordship, for third question, Lordship, the third situation, in this, my case, it is not involved. It is
I'm not in your case. We are generally we are hearing.
so for the academic
Okay.
pursuit,
If your case,
my case is.
do you mean to say that you did not avoid?
No, my case is inquiry was conducted against X. I am YZ.
Mr. Doctor, you are again going to the second issue. Second issue will deal it
No,
separately.
both in these cases, Lordship, in fact, your Lordship judgments.
Yes, continue.
Lordship, further paragraph 20, Lordship. The referral authority, accordingly, we also direct, after discussing the Muslim Mandal and judgment and other, Lordship, the division bench of the Honorable High Court issued some directions. The referral authority must scrupulously adhere to the norms laid down by this court in Muslim Mandal Supra, more particularly as mentioned in paragraph number 96, 97, 98, therein quoted above as otherwise, the proceeding before the tribunal could vitiate. Therefore, the very meaning is that, Lordship, from these directions, if any of the procedure that, because this is giving the opinion is a, Lordship, quasi judicial process. But before that, two stages are there, Lordship. One is regarding inquiry and reference. These are, Lordship, administrative in nature, administrative work. Lordship, and fairness is, Lordship, mandatory in any administrative process. If it is done in an unfair, arbitrary manner, Lordship, it will affect the thing. And secondly, Lordship, Lordship judgment, apart from family members, Lordship, another in a single small line is there indicating the same may be good cause for initiating an inquiry for making a reference against the family members, but without following the due procedure of law of conducting inquiry and making a reference and being adjudicated by the tribunal, the family members cannot be declared to be foreigners. It is Lordship judgment, Lordship, inquiry and reference is necessary. Without inquiry and reference, the person cannot be declared foreigner.
Which judgment is that?
Lordship.
Which judgment is that? Give us a copy.
Citation 2019 1 GLT, page 353. Sudhir Roy, Lordship.
Any more,
Yes, Lordship.
please?
Earlier is Rina Rani Das, Lordship.
Yes, please continue. Mr. Doctor,
Lordship.
please continue.
Lordship is taking up Sudhir Mandal.
Sorry.
Sudhir Mandal judgment.
No, you please continue. You don't stop your arguments.
Lordship. Thereafter, Lordship, since Lordship,
You
thereafter,
please
Lordship,
continue, Mr. Doctor. Why are you waiting?
Lordship,
Yes, please continue. We are not asked you to stop anywhere.
Lordship, thereafter, one judgment of the Lordship, Supreme Court, Lordship, that is. What, may I read it? Lordship?
Yes.
Lordship, all division benches consider themselves to be bound by the judicial precedents created by full bench, not only on the ground of judicial committee, but also on the ground that full bench constituted of more number of judges than a division bench. If a judicial precedent created by full bench required to be considered, then the usual practice was to refer the matter to a full bench consisting of more number of judges than the number which constituted the
This
former.
issue was dealt in detail in the Dayanand case, I think.
This is,
Dayanand is more detailed.
Lordship, this is
I know,
up to
this
the
is-
judgment 2022, Lordship.
You've seen it.
And the next para, Lordship. 44, Lordship, last part. We having carefully considered submissions made by the learned counsel for the parties and having examined the law laid down by the constitution bench in the above decisions, we would like to sum up the legal position in the following terms. The law laid down by this court in a decision delivered by a bench of larger strength is binding on the subsequent bench of lesser or co-equal strength. A bench of lesser quorum cannot dissent from the views taken by a bench of a larger quorum. In case of doubt, all that the bench of lesser quorum can do is to invite the attention of the Chief Justice and request the matter being placed for hearing before a bench of larger quorum than the bench whose decision has come up for decision. It will be open only for a bench of co-equal strength to express an opinion doubting the correctness of the view taken by the earlier bench of co-equal strength, whereupon the matter may be placed for hearing before a bench consisting of a quorum larger than that the one which pronounced the decision laying down the law, the correctness of the said of which is doubted. The conclusion, one, is that the decision delivered by a bench of larger strength is binding on any subsequent bench of lesser co-equal strength. It is the strength of the bench and not the number of judges who has taken a particular view which is said to be relevant. However, conclusion 2 makes it absolutely clear that a bench of lesser quorum cannot disagree or dissent from the view taken by a bench of larger quorum.
Mr. Doctor, which paragraph you are reading?
That's the last part.
Last paragraph.
Last page.
That Justice Hemant Gupta's part.
Yes, Lord.
Last part means which paragraph?
His Lordship, paragraph 6.
Which paragraph?
Lordship will find the last page of the judgment.
Conclusion, that one. G.
Conclusion before that, Lordship, having 12, having at the bottom 12, number 12, having carefully considered the submissions made.
This is in some other judgment, I think. It is only quoted from that one.
Yes, it is Sher Singh, Lordship, State of Punjab. Thereafter, Lordship, in 2008-10 SCC, Lordship.
I think
Paragraph.
one judgment is good enough.
Lordship,
Why do you need more?
78. Lordship.
No, will the proposition become more heavier if you rely on more
Lordship,
judgment?
what this particular judgment says that the unit judicial discipline and unit committee is a It is the rule of law in it was of the constitution.
We understand. We are just asking you on the same proposition, do you need more judgments? One judgment is good enough. That is the law. If you rely on two judgments, will the proposition becomes more heavier or something
Your Lordship, what
of a greater weight?
this
We
particular
accept this. Yes, we have read it. We have read it that a bench of lesser quorum cannot disagree or dissent with the view of law. We have
Yes.
read it. Anything more?
78, Lordship. Hmm? See?
Okay. We heard you.
There I have, Lordship.
On the same proposition, we don't need more than one judgment. We have already accepted the proposition.
Lordship, in this case, Lordship, particular to 2008 NSCC, what stated that in the name of clarifying or modification, the Elisha Dangston even cannot be considered that. If any doubt, anything, if any clarification is required to be
Sorry,
made,
there are other propositions where said even the High Court can clarify a Supreme Court judgment. To that extent, it is possible. There are many judgments on that.
yes, Lordship, but in this judgment, it is paragraph 90, Lordship, that is why I may I read it.
Statement by same.
Paragraph 90, I will read it, Lordship. We are distressed to note that despite several pronouncements on the subject, there is a substantial increase in the number of cases involving violation of the basics of judicial discipline. The learned single judge and benches of the High Court refuses to follow and accept verdict of law laid down by coordinate 2008 Lordship 10 SSC. I have 2008 10 SSC. Official
That's what we said that Dayanand's case, official liquidator versus Dayanand, I think.
official liquidator Dan.
Yes, which paragraph?
Initially paragraph 78 and 1991.
978,
90,
91. Okay. Mm.
71 is Lordship reflected in paragraph 90.
Yes, paragraph 78 and then
90 Lordship.
9.
Lordship, may I read it? Lordship, got it? Page 57, Lordship. We are distressed to note that despite several pronouncements of the subject, there is a substantial increase in the number of cases involving violation of basic judicial discipline. The learned single judges and benches of the High Courts refuses to follow and accept the verdict of law laid down by coordinate and even larger benches by citing minor differences in the facts.
Where you are reading, parent?
90. Lordship.
Yes.
Laid down, coordinate, even citing minor differences in the facts and grounds for doing so.
Where is the provision regarding it cannot be clarified also? You said something that it cannot be clarified. Where is it?
The word is to reconsider.
Where is the word clarify? Because you
Recon-
made a submission that in this judgment, Supreme Court also provided that it cannot even be clarified. Where is that provision?
No, reconsider.
Where is it? So clarify is not there.
Clarify.
So you made a wrong submission.
It is lordship reconsidered.
Where is it? Which paragraph? And what is the difference between clarifying and reconsidering? What is the difference between a smaller bench clarifying a law and a smaller bench reconsidering a law?
No,
What is the difference between the two?
what the lordship, my argument is that since Muslim Mandal is a full bench judgment and the judgment of
Mr. Doctor, we understand what you are arguing.
Reena Rani lordship.
We are just trying to understand from you, as you are heavily relying on several Supreme Court judgments, what is the difference between clarifying an earlier judgment and reconsidering an earlier judgment? Is it one and the same or it is different? Because in course of your argument, we also heard you saying that a smaller bench cannot even clarify. When you ask, where is the exact provision? You say, no, that is not there. Only word is reconsider. So in that context, we want to hear from you, what is the difference between a smaller bench clarifying an earlier order judgment and a smaller bench reconsidering? Is it one and the same or it is different? Okay.
That is judgment leader today.
Yes, I think we are given enough time. Anything more?
Lordship and the Citizenship Act, Lordship has was the question in the initial stage of hearing, Lordship, whether this person will get fundamental right, Lordship.
Who's funda-
Regarding Article 20 fair inquiry, fair trial, Lordship, that part.
Whose fundamental right?
These petitioners who are suspected.
What fundamental right?
Lordship, while Muslim Mandal deals with paragraph,
No.
Article 21,
Those
Lordship.
issues are not involved in this petition. Don't expand it.
Lordship, it is the Article 21, it was
Article
quoted,
21, right to life and liberty. Yes,
right to life and fairness, Lordship.
very well.
Fairness principle, because executive action, these are executive action, inquiry and reference. It has to be fair, Lordship. And because
And what do you understand by the concept fair? What is,
non-arbitrariness,
according to you,
it is non-arbitrariness.
we are not asking you synonyms of the same word. What is the meaning? What is the requirement to satisfy the concept of fairness? What should be done? What should not be done?
What
To
law,
be fair,
what law,
what do you understand by the concept fairness?
Lordship, what law provides and the transparency in doing such.
These are vague submissions. What do you understand by fairness? Suppose today the court has to deal with Mr. Dotto in a fair manner. What do you understand? Mr. Dotto, what do you understand by that?
My basis is, Lordship, paragraph 97, Lordship.
We understand. You are now going to deviating to somewhere else. Just now you made a submission that
Yes,
article.
yes, 97, paragraph 97.
Mr.
Muslim
Dotto, please come to terms.
question, Lordship.
Where moment you submitted Article 21 requires fairness, we are just trying to know from you, what do you mean by the concept fairness? Please confine to it.
It is non-arbitrary, following the procedure established by law, Lordship,
These are
and
synonyms.
transparent. Because question number D, what Lordship is now in Muslim Mandal judgment, the question number D, Lordship, D is specifically in respect of the inquiry, Lordship, and the guidelines has been,
Very good.
some guidelines has been
Yes,
laid down, and Lordship, another aspect is there. In Foreigners Act, Lordship, 6A, Lordship. We cannot put the bull before the cart, Lordship, because E, Lordship, 6A, Lordship. A person shall be deemed to have been detected to be a foreigner on the date on which the tribunal constituted under the Foreigners Order 1964 submits his opinion to the effect that he is a foreigner to the officer or authority concerned.
Yes,
Before that,
I think we have heard you. You are just repeating the same things now. Mr. Paying, where is Mr. Nath? Let us hear it. I think we have made your point. Now you are only reiterating it.
no, Lordship.
You want to say
Lordship,
something more?
kindly appreciate before till date, up to today, only 2-3 sentences I have already submitted. That is, on one sentence is that the judgment of the Muslim Mandal, paragraph 97 is binding, and it is Lordship there in the 90s, paragraph
Mr.
90.
Dotto, these proceedings are recorded. Do you mean to say for the last 40 minutes you have said only 3 sentences?
No,
Mhm.
except today, Lordship. Because on the very first day, Lordship has put a specific
No,
question.
today you have said almost everything you have to say. See, our time is precious. We have to give time to everybody. We have given you a fair hearing for almost 40 minutes. Now the stage has come, you are repeating what you are saying. So therefore, we are putting you to notice. You have to hear the
Lordship,
other side.
question of fair trial, Article 21, everything was come up in this hearing. And I have not stated a single whisper regarding them. Lordship.
You have not said anything till
Yes,
now.
Lordship. Because fair,
Yes.
Lordship has already.
Okay, I give it a whole day today. You argue.
No, Lordship.
Yes, please. Continue. No, you don't, you will not allow you to sit. You continue.
Lordship, I have submitted.
After
that-
hearing you so much, if you still
No,
say
I
that
have-
we are not hearing you, you please continue as long as you want.
No, Lordship.
Please continue. No, you have to. We are not taking up any other matter other than your matter. Mr. Doctor, please continue. Be satisfied to your fullest extent. Yes, Article 21, please start, continue.
Lordship, basically, what if about the fair trial, Lordship, and fair inquiry? Fair inquiry is a the two judgments, Lordship. Fair inquiry, no. Paragraph 38, Lordship, of 2003-6 SCC, page 230, Lordship. Paragraph 38, Lordship.
Two 2003.
2003-6 SCC, page 230, Lordship.
Dwarka Prasad Agarwal.
For the last 5 minutes, you were silent. Please continue with your submission. Don't remain silent. It's a judicial time you will consume. Please continue.
Lordship, then I may be allowed to sum up, Lordship, what my argument would be, Lordship, this, since
Any manner you are comfortable, but please don't waste the judicial time. Don't remain silent. You can do it in any manner you feel like. You can take as much time as you
No,
want,
Lordship,
but you cannot remain silent for 5
Lordship,
minutes.
Lordship.
Please continue.
Lordship, I am waiting whether Lordship has got this.
You don't have
Copy.
to wait for anybody. You continue. We'll ask you to wait if necessary.
Paragraph 38, Lordship. There it is. Lordship, got it.
Please continue. Why are you always putting question on us?
There is another aspect of the matter which must be taken away taken notice of, a party cannot be made to suffer adversely either directly or indirectly by reason of an order passed by any court of law which is not binding on him. Uh, the very basis upon which judicial process can be restored is reasonableness and fairness in trial. Under the constitution as also international treaties and covenants, the right to get fair trial is a basic fundamental human right. And any procedure which comes in the way of a party in getting fair trial would be violative of Article 14 of the Constitution of India. Right to fair trial by an independent and impartial tribunal is a part of Article 14. And another is Lordship. Paragraph 13 of there is 2012 3 SCC, page 126.
120,
126.
paragraph 3,
Paragraph 13, Lordship.
30.
2012 3 SCC, paragraph 126, para 13, Lordship.
30 or 13?
13, Lordship. The issue is akin to ensure equal access to justice. A fair and proper investigation is always conducive to the ends of justice for establishing the rule of law and maintaining proper balance in law and order. These are the very vital issue of democratic setup which must be taken care of by the courts. Therefore, Lordship will consider this matter, and apart from Lordship, Sudhir Mandal, Lordship. Sudhir Mandal, in
Sudhir Roy, not Mandal.
Sudhir Roy.
Mhm.
Yeah. In Sudhir Roy judgment, Lordship has specifically mentioned, without following the due procedure of law of conducting an inquiry and making reference and being adjudicated by the tribunal, the family members cannot be declared to be foreigners. Here is a case, Lordship. The reference was instituted against the head of the family. The second writ petition, second writ petition, item number 2, Lordship. But the tribunal has declared. Reference is in respect of item number 2, Lordship. And the other family members, that is.
Mr. Dotto,
Lordship.
before making a submission, did you go through the record? Or it is your belief that no inquiry was made?
Reference, inquiry and reference. Yes, Lordship.
Before making a submission, because you have made a factually incorrect submission. So therefore, we are asking you, did you go through the record?
Inquiry was conducted only in respect of, Lordship. The petitioner is second writ petition, Lordship. Because the
Forget about second, who is the name of the person? Give the names,
Imtaz Ali, Lordship,
not against others.
not again.
So you are making a statement.
Lordship will find I have annexed the copies, Lordship. This is at page, Lordship, 41, Lordship. As page, at page 41 of the writ petition. Item number 1, Lordship. In item number 1, Lordship, I am reading it. The number so and so, dated so and so, the SI border so and so, Mikirveta PS. It has been learned that
What are you reading, Mr. Doctor?
this is the order to make an inquiry in respect of the Imtaz Ali. The superintendent of police passed an order directing the SI border, Mikirveta police station, to make an inquiry in respect of
Mr.
suspect
Doctor,
Imtaz Ali.
for the second time, we are asking the question. Are you making your submissions after going to the records? Or from your figment of your imagination, you are making your submission?
No, this is a part of page number 42, Lordship.
I don't know page number 42. I am asking you records.
If something is there,
I don't know. It's your case, your prerogative to go
Lordship,
through the record.
kindly take up writ petition page 41, Lordship.
Mind you, we're asking a very serious question. Your submissions are based on material basis or without material basis?
That is why I am referring to paragraph 41, Lordship.
Very well.
And if Lordship may, if Lordship, I would like to go through the record, Lordship.
No one prevented you. 7 days of hearing is already over. No one prevented you from going from the records.
Correct.
Records are always available openly in the court. Anytime we can go through it.
Because Lordship, page 40, Lordship, for the time being, Lordship, take up writ petition page 42, Lordship. Item number. Page 42, Lordship, this is the letter issued, order issued by the Superintendent of Police. It has been learned that Sri Muhammad Intaz Ali, son of late Jamiruddin of village Uttar Kalikazari, Islampur, PS Mikirveta, Morigaon, is suspected illegal migrant who entered India on or after 25th March 1971. You are therefore directed to start an inquiry immediately following all the provisions laid down in the illegal migrants determination rules, and thereafter to submit the report through the screening committee through your immediate superior within 15 days. And thereafter, Lordship, the forms number 1 and 2 are there. Form number 2, name of the person, that is Intaz Ali, Lordship. And
Very well.
another aspect is
Another.
there.
Okay,
Next,
please.
the inquiry officer found, Lordship, during inquiry that the proceeding Intaz Ali was born, Lordship, will take up page 43, Lordship. He was born at Uttar Kalikazari under Mikirveta Police Station, Morigaon district of Assam, Lordship. And if that be so, there cannot be a reference, Lordship. Because inquiry officer himself says the petitioner was born, from his record, Lordship, he was at Uttar Kalikazari Police Station, Mikirveta district, Morigaon, country, India. And at that time of it was 2001. In 2001 he was 42 years old. And the wife of the proceedee was put question. See, Hondehi Patni. Her statement was the suspect is wife. She said that Hondehi Patni. She never said that and police never put any question to her. It was in respect all along to the Intaz Ali, Lordship. Therefore, Lordship, the inquiry was only in respect of Intaz Ali, not to the petitioners.
Okay.
In the first petition, and in the absence of inquiry, the
Mr.
reference
Doctor, I
and
think we have
subsequent.
heard you more than enough. Let us pass our order now.
Otherwise, also, Lordship, I have an
If
next.
you want to have some further ground, please urge. Don't go just repeating the same thing in different words.
Then, Lordship, item number 1, Lordship, writ petition, that is what I have annexed, Lordship, that is the petitioner number 2 and 3. That this is a document of gift deed, Lordship. Get to get here. Get to get 5/8/1967, Lordship. And next is 1971's voter list, Lordship, in the name of grandfather of the petitioner number 2 and 3, Lordship.
What is that land document, 1967, which page?
Page 20, Lordship, original, type copy is 19.
Of which writ petition? Two writ petitions.
First writ petition, Lordship.
Number. WBC number.
37 45, Lord.
3745.
2019.
Page number
Page 19, Lordship.
19. How does it help you? Who is Jamiruddin?
Jamiruddin is the grandfather of the present petitioner number 2 and 3. Lord.
No, please say the name. Name of the persons.
Petitioner. Petitioner number Zakir Hussain and Imrana Khatun, Lordship.
No, whose grandfather is Jamiruddin? Zakir Hussain.
Zakir Hussain and Imrana Khatun. Lordship.
Imrana Khatun and Zakir Hussain's grandfather is Jamiruddin.
Yes.
Okay. Who is the father? Who is the father?
Intaz Ali, Lordship.
Imtaz Ali is the father.
Father.
Which document will show that Imtaz Ali is the son of Jamiruddin of village Nagabandha?
Voter list 1997, Lordship, page 26. The subsequent voter list. Yes, that's what I want.
When did Jamiruddin die? When did he die?
Jamiruddin became very famous. It was not mentioned, Lord.
We want that information. We have to cross-verify the facts. When did he die?
Please.
And if Imtaz was 30 years as on 1997, when did Sarabjan die? What is the name of your sister? What is the name of the sister of Imtaz Ali?
It was 1984, 5 in between. Intaz Ali, Jamiruddin
We
expired.
are asking you some questions. We are not asking you to say whatever you want to say.
Hassan Banu, Lordship.
Hassan Manu. And who is his brother?
Mukhtar Ali Alias Mukhtar Hussain, Lordship.
Mukhtar Ali is better. Where is your voters list along with Hassan, that sister and brother? There must be some voter list together.
Lordship, only document is, Lordship, both of them reflected in the Jamabandi, Lordship. In the voter list,
Where is the Jamabandi?
second repetition, that is page number
Please put the repetition number.
8399, Lord.
8399. 8399. Page number
Page 39 is the
39,
fourth Lordship, the
40.
Jamabandi. And in 41, Lordship, the order of mutation is there. Very different. Last entry in the remarks column, Lordship. Sakra Vikra 27/11/2019 তারিখে নামজারি নাম্বার হুকুম মতে 100
Where is the name of Jamir in the Jamabandi? Either deleted or existing.
at
Hmm.
21 and 22, Lordship.
21,
No,
Jamiruddin.
22
22.
serial number.
Jamiruddin is deleted and his place Nizamuddin. Nizamuddin's name is
No,
included.
Lordship, no, Nizamuddin name is not there. Lordship will find in the right hand column. I will read it, Lordship.
No, come to 21, Jamiruddin. Okay,
No, Jamiruddin is it is not the father of the petitioner. Next 22 is the
okay.
Jamiruddin.
Jamiruddin Pita Khalil.
Khalil.
So now, in place of Jamiruddin, 24, Nizamuddin's name come,
No, 24.
Nizamuddin, Pita Jalil.
It is not. It is Nizamuddin is not the son of Jamiruddin. It is Nizamuddin is son of Jalil.
Sorry.
It is son of some other. 24 is some other potatoes, Lordship.
No, Jalil, son of Jalil.
Yes, my grandfather's
Okay.
name is Khalil, Lordship. Lordship, everything will be clarified by the note, Lordship, in the remarks column. Iman number Jamiruddin Sthalat, Mukhtar Hussain Pitri Jamiruddin,
Where are you reading?
right hand side, Lordship,
Page
last
number,
remark,
page number 40. or
41, Lordship.
41.
Yes.
41, where are you reading?
চক্ৰ বিষয়া 27/11/19 তাৰিখৰ নামজাৰি নম্বৰ হুকুম মতে উক্ত দাগৰ মাটি উত্তৰাধিকাৰী সূত্ৰে জমিৰুদ্দিনৰ স্থলত মুক্তাৰ হুছেইন পিতৃ জমিৰুদ্দিন, মুছা হাছেন বানু পিতৃ জমিৰুদ্দিন আৰু মহম্মদ ইমতাজ আলী পিতৃ জমিৰুদ্দিনৰ নামত নামজাৰি কৰা হ'ল।
Yes. Okay.
Therefore, Lordship,
Anything more? We have taken note what you are. Anything more you want to say? No, because we are running out. Because these matters, if you give hours or after hours, then how many matters will deal in the whole day? Everybody is waiting for their turn.
Lordship, I am concluding.
So I think it's enough concluded. Yes, Mr. Nath, what do you have to say? Issues raised is no inquiry was made in this case, so the whole thing is vitiated. Even if inquiry not made against the other family members, so therefore Sudhir Roy is applicable. Then inquiry means a fair opportunity, Article 21. Then further submission that a division bench cannot do anything with the full bench provision. You are bound by it.
Lordship, what I'm saying, Lord, if Lordship have to disagree with the judgment of Rina Rani.
Please, we have heard you.
No, Rina Rani, Lordship will
Mr.
formulate the question of
Dr.
reference and refer it to a larger.
Mr. Doctor, we have no intention to hear you any further. We have heard you much more than enough. Now let Mr. Nath respond to your submission. So a division bench cannot take a different view. He refers to Dayanand and then one 2022 judgment. Then says that an investigation must be fair. Reference is made to one Supreme Court judgment, 2012 3 SCC. Now, you please submit.
Lordship,
Be precise. We want to.
but the as regard the investigation as indicated in para 97, my lord, my submission will be lord, para 97 will be. But the if the investigation in para 97 is given a strict meaning, a mandate, if it is considered to be a mandatory provision, my lord, before
No, word is not investigation. Word used in 97 is, I think, inquiry.
it says investigation, my lord.
No, no.
Inquiry,
What word is
investigation.
used? Investigation is used or inquiry is used? In para 97, some Muslim model.
Fair investigation and fair trial. That's
No, no. In Muslim model pair 97,
logic.
the word is used is inquiry or the word used is investigation? Fair investigation and fair trial.
Investigation. Para 97 says fair investigation and fair trial being the basic fundamental human right of a person, which are concomitant to preservation of the fundamental right of a person under Article 21 of the Constitution. There has to be a fair and proper investigation by the investigating agency before making a reference to the tribunal. In such investigation, the attempt has to be made to find out the person against whom the investigation is made, so that the person concerned is given the opportunity to demonstrate at that stage itself that he is not a foreigner. Look. In case the person concerned could not be found out in the village where he is reported to reside, or in the place where he ordinarily resides or works for gain, the investigating agency has to record the same in presence of the village elder or the village headman or any respectable person of the locality, which in turn would ensure visit of the investigating officer to the place where such person ordinarily resides or reported to reside or work for gain, and making of an effort to find him out of the, for the purpose of giving him the opportunity to produce the document, etc., if any, to demonstrate that he is not a foreigner. The investigating officer, as far as practicable, shall also obtain the signature or thumb impression of the person against whom such investigation is initiated, after recording a statement, if any, provided he makes himself available for that purpose. There are also instances where the person against whom such investigation is initiated changes his place of residence, maybe in search of livelihood, or maybe to avoid detection, to ensure proper investigation, and also having regard.
So now the question we would like to ask is, suppose the address, the residence, proper identity, whereabouts of a person is not known.
Lordship.
Do we have to construe that para 97 says that no proceeding can be initiated against that man?
But that
This is the only question what
yes,
we are looking into.
but if para 97,
If everything is available, it's well and good. 97 takes care of everything. What happens when a person is only known by his face? The authorities, while exploring the possibilities of who may be a foreigner, who may comes across a person, but nothing is known about that man. Maybe at the best, the name will be known. You ask him what is your name,
Yes.
and then the man disappears.
so
So if 97 is made applicable, that means this man can never be proceeded.
The entire,
So the consequence will be, the law is giving a wide leverage to a person to just disappear. Moment to disappear, the purpose is over. This is what we are looking into. We are not questioning anything what is provided in 97, nor there is any purpose to deviate, although possibly petitioner must have misunderstood the whole purpose of the proceeding. What is the implication of para 97 vis-a-vis a situation where the person is so fluid that neither his residence is known, nor his village is known, nothing is known.
well, para 97 has to be constituted.
Only thing you know is so-and-so and so-and-so.
Look, if para 97 is given strict malad interpretation, then malad the entire provision of the rules under 64 rules will become inoperative, malad. Because in most of the cases, Lordship has seen, malad Lordship, this para 97 may be given in malad an interpretation. It should be construed in such a way, malad, so that the provisions of the act, provisions of the rules,
And further,
can be
this
given effect.
expression used is investigation.
investigation.
Investigation is only under the CRPC.
So this investigation.
No,
will
no,
be Lordship.
no. Any investigation is always under the CRPC. I don't think there is any investigation beyond CRPC. Inquiries are there.
Lordship.
Inquiry can be of different types, different
Yes.
stages, different magnitude,
Lordship. Well,
different
whatever,
volume, everything.
whatever the word is used, but it is investigation.
So we have to
even if-
understand this investigation to be an inquiry, that is.
To be an inquiry, it's a preliminary inquiry, my lord. Only a reasonable doubt has to, if there is a reasonable doubt, then my lord, reference can be made because the provision is very clear. Because the
And
provision,
what is the basis of a reasonable doubt?
my lord, if my lord, the provisions have said that,
Suppose your border police
Lordship,
notices one person X,
Lordship,
okay? Applies its mind to some extent. Then comes to know that he is son of so-and-so or within that locality.
Lordship.
So he's sure that this man is a citizen because he is the son of X, who is a resident of that man, who is understood to be a citizen. So he is a citizen. He comes across another person. Although he knows the name and the probable address, he doesn't know anything about that person.
Lordship.
So this is the situation the border police will be in a given case.
Lordship.
So once this happens, 97 will require that you make a investigation.
If
Not only
investigation-
that, you also go to the village, take the signature of the village headman that if have come.
Well, this is practically not possible. And well, this investigation at this stage, because the burden,
Then why are you not assailing this provision if it is finding it impractical? Why are you allowing it to remain?
well, ultimately the burden lies on him, the person on under section 9. And kindly see, my lord, the investigation, even if some wrong, if there is some wrong in a criminal case also, because of the wrong in the investigation, my lord, the accused person cannot take the advantage of that. So now the argument made by the petitioner that if para 97 is not followed, the entire reference will become bad. That will not be a correct proposition of law.
Okay. You want to submit something more? Or we?
Well, this is a case, my lord, it's relating to criminal trial. Here, my lord, this is 2022 8 SCC 668. Here, while conducting the investigation, the police ought to have, Honorable Court said that police ought to have taken the DNA test. They should have relied on the DNA test. It was not done. Honorable Court said that doesn't make the but I'm just relying 2 paragraphs of this one, para 46 and 47. 22 8 SCC 668.
What does it provide? Please
Lordship.
read.
Here the DNA test was not conducted and the accused appellant said that the investigation is not
No,
proper. So therefore
no,
he should
all
get
the judgments of fair investigation,
lodge.
they all pertain to such situations where there is a possibility that somebody may be wrongly investigated without there being any basis to attain some oblique purpose. You see, almost invariably, all the factual basis of the judgments of fair investigation is that. So therefore, the principle of fair investigation had been propounded. Suppose some authority wants to proceed against X with some vendetta. Lodge a case, FIR. Raise any kind of allegation you want. That authority is also in control of the investigation. Ask them to investigate in a manner that this man is ultimately put within the complete purview of the investigation and rightly or wrongly file a charge sheet, put him, send him to trial. I think in this circumstance, the requirement of a fair investigation comes. Otherwise, every investigation is fair. In a regular case, there are very few cases where there are no fair investigation. In fact, in some cases, unfair investigation would mean that the investigating agency, even after knowing that a person has committed an offense, is trying to protect that person by loosening the investigation. That may be termed to be an unfair investigation, one way. Other unfair investigation is, you know, this person has never committed this thing, get a FIR lodge, make him appear as if he had committed some offense, and pursue your investigation only with the purpose to ensure that this man is brought to trial. This is another facet of an unfair investigation. Otherwise, every investigation is fair. So, how do we understand the concept fair investigation in the fair investigation of para 97 in the context of these cases? So, these cases, the law is very clear that the authority, that paragraph 27 of, I think, Saravanda Sonwal, that last sentence. Supreme Court had taken judicial notice that the authorities may not have any material that this person is likely to be a foreigner, but they are unable to have some satisfaction that he is a citizen. This is also a situation where a reference is
can be made.
justified.
Can be.
So, in this circumstance, if now there is a requirement
Of
that you will have to have
a fair investigation.
complete materials with you, we have to go to that person, give him all the opportunity. If you don't do that, you cannot refer him. Reference will be vitiated. I think in one of the judgment produced by Mr. Dutta, that line is also, it will be vitiated.
So that will
So,
logic.
the authorities are not supposed to have the complete facts, because this is a peculiar nature of matters where only the proceedee will have the fact, will have his own facts. So we feel that the entire purpose of para 97 is give him an opportunity.
It's a fact finding.
Give him an opportunity. If the proceedee desires to come forward, produce relevant materials to show that he is a citizen, the authority will look into it. If the authority is satisfied, that may be the end of the matter there. This particular proceedee will not be proceeded against. If the proceedee produces certain documents which is neither conclusive this way or that way, and the authority cannot come to a definite conclusion that he is a citizen, it is a case for referring to the tribunal because the tribunal will again use its quasi-judicial power. Here it is only a preliminary inquiry.
Yes, my lord.
Third situation is the proceedee is not making himself available. Don't make available. If the proceeding is there, at the end of the day, come back and take the plea. Proceeding is vitiated because there is no inquiry investigation against me.
Lordship.
If we accept the third situation to be also an acceptable situation, does the law not provide the prospective proceedee an opportunity to escape from the whole situation merely by disappearing from the scene or merely by not himself making available? Now, in this context, if you read the last paragraph, last sentence of paragraph 97,
My lord.
last sentence, I mean,
Lordship. But that will ensure a fair investigation and submission
just a
of,
minute.
needless to say,
That will ensure a fair investigation, submission of a proper
Proper
report
report
on
of
such
such
investigation. Needless to say, such investigation need not be a detailed or an exhaustive one,
Lordship.
keeping in view the nature of the proceeding before the tribunal. Object ought to be achieved, hence it will not be.
Lordship.
And why it is said?
As far as technical. In fact, if
Yes.
lordship kindly goes to,
So here
Little-
comes to the, I think it will be the second sentence.
lordship,
In such investigation, the attempt has to be made to find out the person against whom the investigation is made,
Correct.
so that the person concerned is given the opportunity to demonstrate at that stage itself that he is not a foreigner.
yes,
This is the sole purpose.
yes. My lord, the
So this is an
next
inquiry or investigation in the nature of giving an opportunity.
opportunity. Kindly
So
please-
once it is in the nature of giving an opportunity, it is for the other person to either accept that opportunity or to.
Well,
Mhm,
if
mhm.
my lord, considering three situations visualized by your lordship, if it is provided that the referring authority should indicate in their reference that
So
This can-
this part and
Logic.
then again,
next sentence, my lord,
that further sentence to
the-
ensure proper also have regard to integrity and sovereignty of the country. This is also taken care of in para 97.
lordship,
Once investigation to the nationality status of a person starts, he must inform the investigating agency in writing about the change of residence, if any. That means he must also inform the investigation person about his whereabouts. Any failure on this part, on the part of the prospective proceedee, perhaps cannot be taken as an advantage later on, say that I was not inquired, not investigated, everything is vitiated.
that will be,
So,
a disputed thing again.
so 97 has to be read in whole. 97 cannot be read in isolation.
Yes, yes,
And just put it into a and 97 possibly cannot be put into a straitjacket formula and then say the referral authority must scrupulously adhere to the norms laid down in Muslim Model para 97 code. Otherwise, the proceeding before would be vitiated. So this will clarify that this means that if the person is cooperating with the investigation inquiry by providing all relevant material, but the inquiry authority is deliberately preventing or prohibiting him from cooperating with the oblique object that he in either view of the matter, he wants to make a reference, in that case only it will be
This is the
initiated.
Yes, yes, he should not be deprived of the
Ah.
opportunity.
So
He should
we
not be-
will
in-
clarify to this extent.
Yes, yes, not in all situations, not in all.
But it
situations.
cannot be that it's in every situation, irrespective whether the prospective proceeding cooperates or doesn't cooperate or runs away or disappears. At the end of the day, we'll come back to a situation that proceedings should be vitiated, meaning thereby the law is giving a handle to the prospective proceeding,
To evade,
that you disappear from the
to
scene,
evade.
you are protected by everything.
True.
Number one. Number two, what happens if the prospective proceeding is not readily available? Same principle will be
Same
applicable.
principle.
So we clarify to this extent, otherwise we retain everything.
Lordship may also indicate, my lord, that the referring authority will indicate in their reference that the person has cooperated or not cooperated. That will clarify things.
That's all.
If cooperated, 97 has to be followed. If not,
And Mr. Dotto, your submissions that your other family members were not investigated is contrary to the records we have noticed.
Lord,
Yes, start writing.
well, given that, just one point, my lord, the while clarifying, my lord, lordship, two things are just I would like to indicate, my lord. The investigation is not the absolute thing. Ultimately, the court said, Honorable Apex Court has also said that there may be.
No,
some-
this investigation is not a statutory requirement firstly.
It's not a statutory.
It is
requirement.
only on the principles of natural justice that a
Yes.
further provision
Yes,
in view of Article 21 has been brought in by a pronouncement of a
This-
court
all
in
of
a
it.
judgment.
yes.
It's not a statutory requirement.
Lordship.
And with giving due respect to that proposition, you also have to examine what will be the converse to it,
Lordship.
and to that extent,
Yes, yes.
we'll come back and deliver the judgment.
My lord.
And the inquiry was directed the police.
I think it's enough. We just pointed out because we noticed something contrary to what you stated. Yes, start.
And
Heard, Mr. Proceedings can't be prolonged in this manner, that will never allow it to come to an end.
just
I think we heard you much more than what is required. Only thing we said that we noticed something the record contains, but your statement is contrary to that, incorrect. That's why you pointed out. Heard Mr. Yu Dotto and counsel for the petitioner. Also heard Mr. D. Nath, Learned Senegand advocate for the, oh. Mr. Paing and you, between you two, who? Because there is only Home Department, government or some any other Home Department,
Home Depot.
whose name I put.
Petition was commenced. Petition was-
Also heard Baki Sobari Divo.
petition was also-
As the present proceeding also involves a question. As to the provisions, as to the proposition laid down by the three-judge bench of this court in the state of Assam and others versus Muslim Mandal and others reported in 2013 1 GLT 801, comma, and the same having its own implications in the manner in which the state of Assam in the Home Department is carrying out the proceedings against the suspected foreigners, Mr. D. Nath, learned Senegant advocate, also appeared on behalf of the state of Assam in the Home Department.
Respondent number 2.
State of Assam in the Home.
Lordship. Home.
WBC 3745/2019 has been instituted by MUSSTT Asmina Khatun, Muhammad Zakir Hussain, and MUSSTT Imrana Khatun. Being agreed by an opinion dated 12/12/2018 of the Foreigners Tribunal number 3 Morigaon in FTC 203/2015, declaring them to be foreigners. It is noted that how do you read this word? Musammat. Musammat Asmina Khatun is the wife of Muhammad Imtaz Ali, resident of Kalikajari police station, Mikirbeta district, Morigaon, whereas Muhammad Zakir Hussain and Musammat Imrana Khatun respectively are the daughters of Muhammad Imtaz Ali. They're twins. And petition number 2 and 3 are twins or what? Is petitioner number 2 and 3 twins? Full stop. WPC 8399/2022 has been instituted by Muhammad Imtaz Ali, son of Jamiruddin, resident of village Kaligajari, police station, Mikirbeta district, Morigaon, being also agreed by an opinion dated 12/12/2018 of the Foreigners Tribunal number 3 Morigaon in FTC 203/2015. Stop. Yes, Mr. Dotto. Is petitioner number 2 and 3, are they twins?
They're twins.
Sorry,
They're twins.
they're twins.
Yeah.
Are you sure?
Date of birth is the same. Year of birth.
In the writ petition, the petitioners raise a question of law with reference to the provisions in paragraph 97 of the judgment rendered by the 3-judge bench of this court in Muslim Mandal Supra. Muslim Mandal Supra. To the effect that if an inquiry stroke investigation as provided in the said paragraph is not conducted in the manner is not conducted, the resultant proceedings before the Foreigners Tribunal itself would be vitiated, and the entire proceedings are liable to be set aside. A further question of law raised by the petitioners is that the inquiry and the reference had been made only against Muhammad Imtaz Ali being the writ petitioner in WPC 8399/2022, and no such inquiry was held against the writ petitioners, against the 3 writ petitioners in WPC 3745/2019, and therefore, by relying upon the proposition laid down by this court in paragraph 9 of its judgment rendered in Sudhir Roy and others versus Union of India and others, reported in 2019 1 GLT 353, the proceedings against the said writ petitioners in WPC 3745/2019 are vitiated, and therefore the opinion rendered by the tribunal in respect of such writ petitioners are also liable to be set aside. Next para. Over and above the aforesaid 2 questions of law being raised by the writ petitioners, Muhammad Imtaz Ali seeks to discharge the burden under Section 9 of the Foreigners Act 1946 by referring to a voters list of the year 1971 in respect of village Nagabandha, Moza Lahori Ghat, district Nagaon, which contains the name of Muhammad Jamiruddin, son of Khalil, at serial 1063. The petitioner Muhammad Imtaz Ali also relies upon the voters list of 1965 of village Nagabandha, which contains the name of Jamiruddin, son of Khalil, at serial 194, Mosammat Sabarjan, wife of Jamiruddin, at serial 195, and that of Muhammad Muqtab Ali, son of Jamiruddin, at serial 196, by claiming that Mosammat Sarabjan is his mother and Muhammad Muqtab Ali is his brother. Let's stop. Petitioner also places reliance on, where is the Jamabandi? 39. On (39) is not Jamabandi. 39 of which writ petition?
WPC
Of the 2019 writ petition. Also relies upon a Jamabandi in respect of a plot of land in village Nagabandha, wherein, as per the order of the circle officer dated 27/11/2019, the land had been mutated by deleting the name of Jamiruddin, son of Khalil, and including the names of Muqtab Hussain, son of Jamiruddin, Mosammat Hussain Banu, daughter of Jamiruddin, and Muhammad Intaj Ali, son of Jamiruddin. Accordingly, the writ petitioner Intaj Ali claims that he is the Intaj Ali as per the order of the circle officer dated 27/11/2019, and therefore son of Jamiruddin, son of Jamiruddin of village Nagabandha, whose name appears in the voters list of 1971 of the said village, and therefore he is a citizen.
The Jamabandi was not before the tribunal at that time because the order was passed in 2018.
Mr. J. Payeng, Land Counsel for the Home Department, states that the Jamabandi relied upon by the petitioner was not before the tribunal because
It was
the tribunal had because the proceedings in the tribunal was prior to the order of the circle officer dated 27/11/2019. Mr. D. Nath, learned Senegal advocate, appealing for the Home Department of the Government of Assam, raises the contention that the provisions of the propositions laid down in paragraph 97 of the judgment of the judgment of this court in Muslim Mandal Supra are provisions in furtherance of Article 21 of the Constitution of India, and it does not lay down a jurisdictional procedure so that in the event an inquiry or investigation contemplated under the said proposition could not be carried out in a given case, the same would vitiate any proceedings that had been initiated before the Foreigners Tribunal without due adherence to the procedure laid down in the said paragraph 97. Mr. D. Nath, learned Senegal advocate, raises the contention that these proceedings are of a different nature vis-a-vis any other criminal investigation or proceeding, wherein the prospective foreigners do have a tendency that whenever any inquiry stroke investigation is being contemplated or carried out, the first effort is to disappear and make themselves unavailable for the inquiry and the investigation. Full stop. By exhibiting such nature, the attempt of the prospective proceedings are to avoid the judicial system of being detected whether the person concerned is a foreigner or not. According to the learned senior counsel, to mitigate such eventualities, the provisions of Article 29, para 97 of Muslim Mandal Supra would have to be read in the context of each individual case. So, Mr. U. Doctor, learned counsel for the petitioner, has raised a submission that the provisions laid down in para 97 of next paragraph, in the para 97 of Muslim Mandal Supra is Muslim Mandal Supra is a provision which would be mandatory in nature, and any deviation thereof would lead to the subsequent proceeding that may be initiated to be vitiated. The further submission raised is that Muslim Mandal is that a judgment in Muslim Mandal Supra having been rendered by a 3-judge bench, comma, a division bench cannot take a contrary view, as it would violate the principle of judicial discipline, and therefore the question raised by the state authorities cannot be gone into. To support his contention, Mr. U. Dr. Learned Counsel for the petitioner relies on the pronouncement of the Supreme Court rendered in rendered in MS Trimurti Fragrances bracket P Limited through its director Shri Pradeep Kumar Agarwal versus Government of NCT of Delhi through its Principal Secretary bracket Finance and others, reported in 2022 bracket 2022 AIR bracket SC 4868. Reference is made. Which paragraph, Mr. Dutta? Somewhere in the last you said. Sorry, G. E. To
And the last.
to paragraph F, wherein an earlier judgment of the Honorable Supreme Court rendered in Central Board of Dawidi Bohra Community and another versus State of Maharashtra and another, reported in 2005 to SCC 673, was quoted. And thereafter, in paragraph G, capital G, a conclusion was arrived that a decision delivered by a bench of larger strength is binding on any subsequent bench of lesser or co-equal strength, and that it is the strength of the bench and not the number of judges who have taken a particular view which is said to be relevant. Accordingly, a conclusion arrived was that it is absolutely clear that a bench of a lesser quorum cannot disagree or dissent from the view of law taken by a bench of a larger quorum. And quorum means the bench strength, which was hearing the matter. Mr. Doctor, in his submission, also refers to the pronouncement of the Supreme Court in official liquidator versus Dayanand and others reported in 2008-10 SCC 1, wherein, which paragraph?
Paragraph 78, 90 and 91.
Wherein in paragraph 90, it had been held that in paragraph 90, the Supreme Court observed that despite several pronouncements on the subject, there is a substantial increase in the number of cases involving violation of the basics of judicial discipline. And that the learned single judges and benches of the high courts refuse to follow and accept the verdict and law laid down by coordinate or even larger benches by citing minor differences in the facts as the ground for doing so. The Honorable Supreme Court concluded that therefore it has become necessary to reiterate that disrespect to the constitutional ethos and breach of discipline have grave impact on the credibility of the judicial institution and encourages chance litigation. Change code even. Change code. You have referred to something more? That one High Court judgment.
Yes.
That is Reena Rani Das, I think. By raising the submission that a division bench cannot take a different view from that of the proposition laid down by a three-judge bench. Mr. U. Dottol and counsel for the petitioner refers to another division bench judgment of this court in Reena Rani Das versus Union of India and others. In WPC 2706/2019, in its order dated 10/3/2021, wherein,
This is reported, Lordship. I'm
please
sorry.
don't disturb.
Lordship, citation is there. Lordship.
Mr. Doctor, please don't disturb in the middle of the judgment. If you have anything, tell it in the end of the order. Not in between. We cannot allow you to do that. Keep quiet, Silu. The 19, wherein the provisions of paragraph 97 of the judgment of the three-judge bench in Muslim Mandal Supra was deliberated and discussed. In paragraph 16 of the judgment in Rina Rani Das Supra, it was provided that a proper pre-referral investigation is absolutely necessary to obviate the problem that had arisen in the matter before the court in Rina Rani Das. In Rina Rani Das Supra, the issue was that while serving notice on the proceeding, the person against whom the proceedings is to be initiated was not properly identified. Inasmuch as there was an attempt that the opinion rendered by the tribunal was given in respect of inverted comma Rima Das, which again was sought to be made applicable to inverted comma Rina Rani Das. In the aforesaid circumstance, the court examined the relevance of an inquiry-stroke investigation before the proceeding was initiated, and in the circumstance arrived at its conclusion in paragraph 16 that a proper pre-referral investigation is absolutely necessary to obviate such problem, that is, to avoid the problems of identity of an opinion being made applicable to a person against whom there was no reference or no proceeding held. Accordingly, the court expressed a view that pre-referral investigation cannot be mechanical and there must be proper application of mind by the authorities concerned, and that the persons concerned in the locality, including the proposed proceeding, must be examined wherever possible. In the circumstance, in paragraph 20 of the said judgment in Rina Rani Das Supra, the division bench had held that the referral authority must scrupulously adhere to the norms laid down in paragraph 96, 97, and 98 of Muslim Mandal Supra, as otherwise the proceeding before the tribunal would be vitiated. Mr. Yu, Dr. Learned Counsel for the petitioner, without much reference to the circumstance in which the under which the proceeding against Rina Rani Das was held, merely seeks to rely upon the provisions of para 20 bracket 1, 21 bracket 1, wherein it was held that if the provisions in paragraph 97 of Muslim Model Supra is not scrupulously followed, the proceeding before the tribunal would be vitiated. Mr. Yu Das, Dr. Learned Counsel for the petitioner, seeks to raise the contention, raise his submission that in the instant case, the petitioner Muhammad Intaz Ali was not appropriately inquired or investigated prior to Imtiaz Ali and his family members were not appropriately inquired or investigated, and therefore the proceeding as well as the resultant opinion dated of the tribunal would be vitiated. With regard to the other submission of Mr. Yu Dutta, that the writ petitioners in WPC 3745/2019, who are the family members of the other writ petitioner Muhammad Imtiaz Ali. Sentence. Were not duly inquired or investigated. Comma, could not have been referred in the same reference as made to Muhammad Imtiaz Ali, and for the purpose relies upon the proposition in Sudhir Roy Supra and submits that the proceedings against the writ petitioners in WPC 3745/2019 are vitiated, although otherwise it may be maintainable against the other writ petitioner Muhammad Imtiaz Ali. Which judgment did you refer? You referred one particular judgment.
Well, this is on the point of investigation is not mass murder. Even if some difficulty is there in the investigation, the accused person cannot get the benefit of that, because in the trial he has to prove it.
Mr. D. Natlan, Syndicate Advocate for the Home Department of the Government of Assam, on the other hand, relies upon the pronouncement of the Supreme Court rendered in Virendra versus State of MP, reported in 2022 8 SCC 668, wherein it had been held that merely because of certain defects or shortcomings in the investigation, an accused who had been subjected to a criminal trial cannot get acquitted only for the reason of certain shortcoming or defect in the investigation itself. Accordingly, Mr. Sri D. Nath seeks to invoke the same principle in the instant case and submit that even though the inquiry or the investigation was not carried out or not carried out as per the requirement of law in respect of the writ petitioners, the same by itself will not vitiate the resultant proceedings that had been initiated against them, merely on the reason of such shortcoming or defect in the investigation. We've heard the learned counsel for the parties. As regards the issue raised by Mr. Yu Dutta, learned counsel for the petitioner, that it would be inescapable for the authorities to not conduct an inquiry or investigation. As provided in paragraph 97 of Muslim Mandal Supra. People, sentence.
Not to conduct an inquiry or investigation that provided.
Called inescapable, so not to go. Before referring for an opinion by the Foreigners Tribunal as regards the citizenship of a person. And therefore, and the said provision having been laid down by a three-judge bench, a division bench would not have the jurisdiction to take a different view, comma. We find that from the issues raised by the state of Assam as regards the provision of paragraph 97 of the judgment in Muslim Mandal Supra, comma, this court has not been called upon to render any judgment to take a view which would be different or in deviation to what had been already laid down in Muslim Mandal Supra. We are in agreement with the, we are in respectful agreement with the propositions laid down by the Supreme Court in paragraph 1 of its judgment, paragraph outside of its judgment rendered in what was the first one? 2022. National infrastructure. Right? In MS Trimurti Fragrances P Limited, in paragraph F, capital F and G thereof, as well as with that in Dayanand Supra in paragraph 90 and 92, 91 thereof. Neither this call is called upon to take a view which would be different or in deviation of what is provided in para 97, nor the court intends to take a view which would be different or in deviation of paragraph 97. The issue raised by the Home Department of the Government of Assam is that in the peculiar nature and circumstance of the present proceedings, situations are also faced where a proceeding deliberately avoids appearing before the inquiring or investigating authorities, with the intention that by not appearing before the authorities in the inquiry or investigation and they can subsequently take a technical view that there was either no inquiry or investigation, and therefore, as held in paragraph 20(1) of the judgment of this court rendered in Rina Rani Pal, comma, Rina Rani Das Supra, they can take the stand that the entire proceeding initiated against them is vitiated. কি করবো সেন্টেন্সটো দীঘল হয়েছে।
The issue raised by the public company of the particular nature and significance of the present opportunity. The situations are always faced because the opportunity deliberately upon securing before the inquiry or investigation of the injection that are not escaping before the authorities in the control or investigation. They can subsequently take execution to the care of private exposure. Their forecast health record one of the government of the we take the proceeding
Full stop. If such situations do happen with the referring authorities, comma, certainly it is a matter of concern. And it would be an escape route for a prospective proceeding to avoid the proceedings and being declared as a foreigner merely by disappearing and making themselves unavailable before the inquiring authority, and ensure that in spite of all efforts, the inquiring authority is unable to do the needful as required, as provided in para 97 of the judgment in Muslim Mandal Supra. In this proceeding, we are required to look into the issue only from the aforesaid perspective and not from the general perspective as to whether the provision in paragraph 97 in Muslim Mandal Supra can be diluted to some extent, or that a different view or a deviated view is required to be taken of the provisions thereof. In this circumstance, we examine the provisions of paragraph 97 of Muslim Mandal Supra, which is extracted as below, and understand as to what are the exact provisions and propositions laid down therein. From paragraph 93 quote kori dia. Extract to 93 to 97 or 98 also.
98.
98 also
Yes.
are extracted as below. Ninety-two. In paragraph 92 of the judgment in Muslim Mandal Supra, a question being one inverted comma question D, question bracket D, had been framed as to in what manner the investigation is to be carried out by the instrumentality of the state before making a reference to that tribunal under the provisions of the 1964 order. In paragraph 93, it is provided that the right to get a fair trial is a basic, fundamental, and human right. And that a fair trial also includes a fair investigation. In paragraph 93, it is further provided that the right under Article 21 of the Constitution is available to all persons to protect his life and personal liberty, and hence even the right of a non-citizen to have a fair investigation, trial, as well as fair procedure to be adopted by the tribunal is guaranteed under Article 21 of the Constitution. Accordingly, it is to be understood that the right to have a fair investigation is derived from the fundamental rights under Article 21 of the Constitution of India. Where is the judgment of fair investigation? You refer to one judgment.
This is 2003 6 SCC
Which paragraph?
38
38.
and
To substantiate the submission on the requirement of there being a fair investigation, the Mr. U. Dattol and counsel petitioner relies upon the proposition laid down in paragraph 38 of the judgment of the Supreme Court in Dwarka Prasad Agarwal versus B.D. Agarwal, reported in 2003 6 SCC 230, which is extracted as below. We'll come back. We'll take some time. We'll come back at 2. Reference was made to para 38 of in that Dwarka Prasad Agarwal. What relevance does it have? Where is it? The judgment cited by the learned counsel for the petitioner, that is paragraph 38 of in Dwarka Prasad Agarwal D. Supra, does not appear to be a relevant provision. On the submission on the requirement of a fair investigation. But as in Muslim Mandal Supra, a three-judge judgment of this court had provided that fair trial also includes a fair investigation. We look into the aspect of what would be a fair investigation in respect of the proceedings under the Foreigners Act. Most of the judgments enunciating the principle of fair investigation pertains to an investigation in a criminal matter, where an investigation is being carried out to achieve some other oblique purpose rather than it being an investigation in a matter where certain serious criminal allegations are raised by one party against another. They are being raised, one party are being raised, or where serious allegations are being raised, the investigations are deliberately not done in a required manner so as to give undue advantage to a prospective accused. But for the purpose of the proceedings under the Foreigners Act, a fair investigation would be fair enough if the prospective proceedee is given an opportunity to present his claim before the inquiring or the investigating authority that he is otherwise a citizen of India. The said provision can also be, the said requirement can also be found in the proposition laid down in paragraph 97 of Muslim Mandal Supra. In paragraph 97, in paragraph 97 of Muslim Mandal Supra, it has specifically been provided that a fair investigation would be a concomitant to preservation of the fundamental right of a person under Article 21 of the Constitution of India, and in such investigation, the attempt has to be made to find out the person against whom the investigation is made, so that the person concerned is given the opportunity to demonstrate that demonstrate at that stage itself that he is not a foreigner. The proposition in paragraph 97 in Muslim Mandal is consistent with what we have already held, that in respect of a proceeding under the Foreigners Act, a fair investigation would be sufficient if an opportunity is given to the prospective proceeding to present or demonstrate with any relevant material that he is not a foreigner or that he is an Indian citizen. The provisions of paragraph 97 itself makes it discernible that the dominant purpose of an investigation or inquiry is to provide the prospective proceedee with an opportunity to present or demonstrate that he is an Indian citizen or that he is not a foreigner. But again, the said requirement to give an opportunity to the prospective proceedee to demonstrate or to present or demonstrate that he is not a foreigner is again qualified with the further provisions of paragraph 97, which provides that to ensure proper investigation and also having regard to the integrity and sovereignty of the nation, once an investigation relating to the nationality status of a person starts, he must inform the investigating agency in writing about the change of residence, if any, thereafter. The said provision itself makes it the said provision in paragraph 97 itself makes it inherent that to avail the benefit of the opportunity to be given during the investigation, a corresponding cooperation from the prospective proceeding is also a requirement. And the requirement is to the extent that the proceedee must at all point of time during the process of the investigation should make it known to the investigating authority about his whereabouts or his location where the authority may find him. A corollary to the said provision of requiring the prospective proceedee to inform the investigating authority about his whereabouts would also be that there is a requirement of the prospective authority, prospective proceedee to cooperate with the investigating authorities. Next paragraph. The said provisions within which are inbuilt within paragraph 97 itself of the Muslim Mandal Supra makes it apparent that the provisions thereof are not to enable a prospective proceedee to move away and disappear from being available before the investigating authorities to continue with the investigation. In this respect, we also take note that the requirement of an inquiry preceding a reference made to the Foreigners Tribunal is a provision of Rule 3 of the illegal migrants bracket determination by tribunal rules 1984, which is extracted as below. Rule 3 of the illegal migrants determination by tribunal rules 1984 makes it a requirement that for the purpose of making a reference under section 8 of the Illegal Migrants Determination by Tribunal Act 1983, there is a pre-requirement that the superintendent of police to make an inquiry through an officer not below the rank of a sub-inspector of police. As to whether the questions referred in section 8 or section 8A of the Act of 1983 exist in a given case. Section 8(1) of the Illegal Migrants Determination by Tribunals Act 1983 provides for a representation to be made by any such person against any order under the Foreigners Act requiring him not to remain in India or to any other effect. Whereas section 8(1) refers to any person making an application to the tribunal for its decision as to whether the person whose name and other particulars are given in the application is or is not a foreigner. Rule 3 of the full stop. But be that as it may, the Honorable Supreme Court, by its judgment rendered in first to second or first, Amnesty Act set aside
One.
one. The Honorable Supreme Court, in its judgment rendered in Hormonal Sonwal, it will be reported in so and so,
2005, 5 SCC,
Five.
6665,
5 SCC
65.
660 had set aside, had struck down the illegal migrants determination by Tribunal Act 1983, meaning thereby that as a corollary thereof, Rule 3 of the Illegal Migrants Determination Tribunal Rules 1984 had also been set aside by implication. In such situation, there would be no statutory requirement for the referring authority to make any inquiry to precede a reference made to the tribunal. But however, in paragraph 97 of the judgment in Muslim Mondol's Supra, the three-judge judgment brings in the requirement of an inquiry or an investigation. To be, by providing it to be a requirement of Article 21 of the Constitution of India. As the requirement to make an inquiry is no longer a statutory requirement, but a requirement as provided in paragraph 93 of the judgment in Muslim Mondal Supra, we'll have to understand the purport, nature, and extent of the inquiry as provided in para 97 of Muslim Mondal Supra. As already in as already indicated above, the dominant purpose of the provisions of section 90, para 97 of the judgment in Muslim Mondal Supra is to afford the prospective proceedee an opportunity to present or demonstrate before the investigating authority itself that he is not a foreigner. The further provision is that the prospective authority have to keep the investigating agency informed about his whereabouts, and also to give the specific location as to where he may be found in the event the prospective proceedee decides to change his place of residence. The provision in para 97 of Muslim Mondal Supra itself makes it imperative that the prospective proceedee have to keep himself within the make himself available within the make himself within the availability domain of the investigating agency, which again would mean that he is not expected to make himself disappear from the availability of an investigating agency to frustrate the investigation. Full stop. Accordingly, we clarify that the provisions of paragraph 97 of the Muslim Mondal Supra is available for the purpose of affording the prospective proceedee an opportunity to demonstrate or present that he is a citizen of India or that he is not a foreigner. And it cannot be understood to be a provision which may enable the prospective proceeding to frustrate the inquiry or the investigation by making himself deliberately unavailable to the investigating authority and thereafter take advantage of his unavailability and take the stand that the proceeding that may be drawn against him would be vitiated. We are clarifying further that we are not in any manner deviating, disagreeing, or diluting the provisions of paragraph 97 of Muslim Mandal Supra, but only clarifying to the extent that what would be the effect if a prospective proceedee deliberately disappears and make himself unavailable before the investigating authority so as to frustrate the entire judicial system. When he perused the records of the instant case, it is noticed that the investigating authority had given adequate opportunity to the writ petitioner Muhammad Imtaz Ali. Imtaz Ali, as well as to the writ petitioner Asima Khatun. As appropriate opportunity had been given by the investigating authority to the aforesaid two writ petitioners, it cannot be said that the requirements of para 97 of the Muslim Mandal Supra was not complied with. But in respect of the writ petitioners, records do not reveal, writ petitioners Muhammad Zakir Hussain and Muhammad Imran Khatun, records do not reveal that the investigating agency had given them an opportunity. Mr. Yu Dottol and counsel for the writ petitioner has raised another contention that the writ petitioners Muhammad Asima Khatun, Muhammad Zakir Hussain and Muhammad Imran Khatun had been referred along with their husband stroke father, namely Muhammad Imtaz Ali. And therefore, the reference made in respect of that said three writ petitioners would be vitiated in view of the proposition laid down in paragraph 9 of the judgment rendered in Sudhir Roy Supra. In paragraph 9 of the judgment rendered in Sudhir Roy Supra, it had been provided that it may be a good cause for the referring authority to initiate an inquiry and make a reference against the family members of a proceeding, but without following the due procedure of law of conducting an inquiry and making a reference and being adjudicated by the tribunal, comma, the family members cannot be declared to be foreigners. In the instant case, we have noticed that the inquiry had been made against the writ petitioner Musammat Asima Khatun. As revealed from the records. From such point of view, factually, the proposition laid down in para 9 of Sudhir Roy Supra would be inapplicable in respect of the writ petitioner Musammat Asima Khatun. Full stop. Accordingly, we hold that the reference and proceeding that had been made we also note that there is nothing indicated in the record that the writ petitioners Muhammad Zakir Hussain and Musammat Imran Khatun had made themselves unavailable before the inquiring or the investigating authority, so as to disable the authority to make any inquiry. Accordingly, we hold that the reference as well as the opinion dated so and so rendered against the writ petitioners Muhammad Zakir Hussain and Musammat Imran Khatun would be unsustainable in law. But however, as the said declaration is made on a technical aspect of a combined reference being made against the said two writ petitioners, along with their father Muhammad Intaz Ali, in deviation of the proposition laid down in para 9 of Sudhir Roy, comma, we grant liberty to the referring authority, if so advised, to make and to give the said two writ petitioners, namely Muhammad Zakir Hussain and Musammat Imran Khatun, an opportunity to present any material that they may have to prove that they are citizens of India. And upon such opportunity, liberty remains to make a reference, if so advised and maintainable under the law. As regards the writ petitioners Muhammad Intaz Ali and Musammat Asima Khatun, comma, as the records reveal that the required procedure of law had been followed, we now examine the submission raised by the said two petitioners for discharging the burden under Section 9 of the Foreigners Act that they are citizens of India. Full stop. Where is the Jamabandi? Which page? And Jamabandi page 40, I think, not 40.
Page 39, Lordship, in
Page 39 of
8399.
of WPC
8399.
839.
99.
And where is that voters list?
Voters list, Lordship, at page 27 in the
Page
Same reading.
27.
7.
In respect of the writ petitioner Muhammad Intaj Ali, reliance is placed. Not started something from earlier.
And earlier is Lordship has
Jamiruddin. Reliance is placed on the voters list of 1971 of village Nagabandha, police station Lahori Ghat, Mouza Lahori Ghat, district Nagaon, which contains the name of Muhammad Jamiruddin, son of Khalil at serial 1063. Thereupon, reliance is placed on the voters list of 1985 of village Nagabandha, which contains the name of Jamiruddin, son of Khalil at serial 194, Muhammad Sarabjan, wife of Jamiruddin at Muhammad Musamad at serial 195, and Muhammad Muqtab Ali, son of Jamiruddin at serial 196. And accordingly, claim is made that Muhammad Sarabjan, wife of Jamiruddin, is the mother of Imtaz Ali, and Muhammad Muqtab Ali, son of Jamiruddin, is the is the brother of Imtaz Ali. Thereupon, reliance is placed on the voters list of 1997 of village Nagabandha, which contains the name of Imtaz Ali, son of Jamir, and Asima Khatun, wife of Imtaz, by referring to son of Imtaz at serial 340 and 341 respectively. By referring to serial 340 that Imtaz Ali is the son of Jamir of Nagabandha village, linkage is claimed with Jamiruddin of the voters list of 1971 of village Nagabandha to claim that Imtaz Ali is also a citizen of India. But the further voter list of 2015 relied upon by the petitioner contains the name of Imtaz Ali, son of Jamir at serial 805, but this list is in respect of village Kalikajari, police station Mikir Bheta in the Morigaon district. We have noticed that the notice of the tribunal is issued against Muhammad Imtaz Ali, son of late Jamiruddin of village Uttar Kaliha Jari, Islampatti. Full stop. No material is available before the court other than the claim of the petitioner that the Imtaz Ali of the voters list of 1997 of village Nagabandha, Imtaz Ali, son of Jamir, and Muhammad Imtaz Ali, son of late Jamiruddin of village Uttar Kaliha Jari Islampur are one and the same person. Full stop. The petitioner also refers to a Jamabandi, a copy of the Jamabandi, wherein an order of the circle officer dated 27/11/2019 is referred, which provides that in respect of a plot of land bearing Dag number 184 of village Nagabandha, the same had been mutated by deleting the name of Jamiruddin, son of Khalil, and substituting it by the name of Muhammad Muqtab Hussain, son of Jamiruddin, Musammat Hassan Banu, daughter of Jamiruddin, and Muhammad Intaj Ali, son of Jamiruddin. There is no difficulty to accept that Intaj Ali, son of Jamiruddin of village Nagabandha, may be a citizen of India. But whether the proceedee, who is Muhammad Intaj Ali, son of late Jamir Uddin of village Uttar Kaliara, Kaliari, and the Intaj Ali of the Jamabandi of Nagarbandha, as well as the voters list of Nagarbandha, are one and the same person, requires a determination. For the purpose, matter remanded back to the tribunal to enable the petitioner Muhammad Intaj Ali to adduce any evidence that he may desire to rely upon to substantiate that Muhammad Intaj Ali of the Nagabandha voters list and Jamabandi and Muhammad Intaj Ali of village are one and the same person. As regards the writ petitioner Musammat Asima Khatun, no material is placed before the court that she is a citizen of India. Muhammad Asima Khatun would have to prove her citizenship through the lineage of her father and not through the lineage of her husband, Muhammad Intaj Ali. As no material is made available, we also allow another opportunity to the writ petitioner Musammat Asima Khatun to adduce any evidence before the tribunal which may establish that she is a citizen of India and thereby discharge the burden under Section 9 of the Foreigners Act 1945. The writ petitioner Muhammad Intaj Ali and the writ petitioner Musammat Asima Khatun to appear before the which tribunal?
Morigaon.
Before the Foreigners Tribunal number 3
Number-
Morigaon on so and so date that will be booked.
6th May.
And the tribunal may pass any reasoned order as may be advised upon the materials that may be produced by the said two writ petitioners. With respect to the writ petitioner Muhammad Zakir Hussain and Musammat Imrana Khatun, liberty remains with the respondent authorities to refer to them if so advised by following the due procedure of law as indicated.
I would like to. There is citation will have.
LCR and deck.
Till such reason order passed, no coercive action be taken. You know, to go.
For admission item 21 to 26.
Please, your lordship. May I please? I would like to hand it over to your lordship some international treaties and conventions. Give the copy. Everything. Two copies, no? Yeah. Yeah, अलग-अलग copy बना के दिखाएंगे। No. We have prepared a note for your lordship. But there are various international treaties and conventions. And we have marked 3-4 rights in it, my lord. My lord, if I may read this compendium.
Mr. Majumdar. Yesterday, we deliberately we put one question to you. Are the illegal migrants homogeneous? Or there is a class of difference between them?
I will not say absolutely homogeneous, class apart, madam.
No, if it is not homogeneous, why I'm putting this question?
Why?
Whatever material is produced, we'll read it by considering it to be a homogeneous class and then apply it. Or we read it to be a non-homogeneous class. And if it is so, what about its applicability?
Of these
It will be
variables.
high, it will be equally applicable, or again, because of the class differentiation, some will be applicable, some may not be
Well,
applicable.
I'll go with the second, some will be applicable, some will not be applicable.
My lord. First of all, I would like to take you to the Universal Declaration of
No,
Human.
the first one I got is a table, international treaty obligations and socio-economic rights.
My lord,
Which one do you want me to take up first?
this one only, but the first page is Universal Declaration of Human Rights.
Okay.
Slowly, we will go into other treaties and conventions.
Hmm.
On the right,
So, from the Universal Declaration of Human Rights,
my lord,
you pick up Article 25.
25.
Everyone has the right to a standard of living adequate for the health and well-being of himself and of his family, including food. This we agree, Mr.
My lord,
We are already agreeing with you.
my lord. No, there are other rights also.
Mr.
No, we
Awad,
have argued.
these issues, we have no difficulty with these issues.
My lord,
We have told you on many occasions, we are agreeing with you.
my lord.
Only thing is, in what manner this right is to be given effect. This is where yesterday we are trying to refer to the NFSA, we were trying to refer to some ration card. We had put you some questions. On a broad-based manner, right to food, right to work and livelihood, right to health and right to education,
My lord,
I think even the state respondents may not object to you. Yes, Mr. Modi, are you
Yes, yes.
vehemently objecting to these things? I
Right
don't
to
think
food,
so.
he always,
So you don't have to establish it.
My lord,
And we have also told you that the basic human rights has to be respected,
my lord,
whatever category of person you may be.
my lord,
This is not the issue.
my lord.
Issue is how to give effect to these rights. While giving effect, what you'll be entitled and what you'll not be entitled. God-based is no difficulty.
We have another note
Hmm.
on how these rights are given to
How it will be, how you want to implement or give effect to these rights.
my lord.
Please submit on that.
There is another note,
Mr. Young Counsel,
my lord.
you're from Guwahati?
I am from Guwahati.
No.
No, lordship.
Hmm. No, because- It's not appropriate. Yeah. Ayushman Bharat Health Card.
Lord, if I am, if the DFNs are granted right to health, then these cards should be granted to them. Otherwise, they won't be able to avail the schemes under right to health. Even under right to livelihood, we have given some list, my lord.
No, I understand. We'll hear them on what you have to say. Definitely. Because this is a very, considering the class of people we are dealing with, it's a very sensitive issue actually. It's neither, it's, everything can't be put in a very straight jacket way. That's a
My lord,
difficulty.
my lord.
We'll ask them. If they agree, we definitely will
Yes.
pass the order.
With your lordship permissions, suppose if I put a question to the state that
Is Constitution. There. Mr. Awan,
my lord,
these schemes, although some may be having a little statutory character, some may not be having statutory character. But ultimately, these are fallout of part 4 of the Constitution, I believe, directive principles.
should be.
Mr. Mojumdar and Mr. Chaudhary, these schemes that Ayushman Bharat and all, these are outcome of part 4 of the Constitution, it appears. Directive principles. If these are outcome of part 4, Supreme Court has said that they provide for guidance to interpretation of fundamental rights of citizens. These directive principles
My lord,
are a guidance for implementing the fundamental right of the citizens. So if these are fallout of directive principles, what about its applicability to non-citizens?
if I may say this, your lordship, suppose, for example, the right to health is a fundamental right and a DFN is entitled to right to life. Now, I put this question to myself.
No. We are again trying to distinguish between a broad-based claim of right to food, right to life, right to education, and right to health.
my lord,
And in what manner, in respect of these category of people, that right has to be implemented. This is what we are trying to examine. Broad-based, it's okay.
my lord,
We all agree. And even the respondents are not disputing it.
my lord,
So you don't have to establish it again and again that these rights are available. For the purpose of implementing it,
my lord,
if you refer to some schemes
my lord,
which are outcome of the fundamental of part 4 directive principles,
my lord,
and directive principles are guidance for implementing the fundamental right of the citizens.
my lord,
So ipso facto, whether these schemes as such will also be applicable to a foreigner. This is what we are trying to examine.
very well, my lord. I just want to put one question to the state. Suppose they are granting me right to health. Suppose a DFN is suffering from cancer.
We are not here to answer what question you put to this thing. We are here to hear your submission so that we can pass a judgment.
My apologies. I will submit before your lordship. So, for example, a DFN is suffering from cancer. He has to be treated with chemotherapy. Now, what are the procedure, my lord? Now, he just cannot go and land up in some primary health care center because it's not available there. He will have to go to some good health center or hospital where if he cannot pay the money, then my lord, these are the cards: Ayushman Bharat card, Atal Amrit Abhiyan scheme. 2 lakhs is paid under this scheme. 5 lakhs is paid under the Ayushman Bharat health card. Without this card, my lord, it is not possible to avail a chemotherapy, my lord.
Your answer to your question you are trying to raise,
My lord,
come to section 3CC of the Foreigners Act.
my lord, section 3.
CC.
Yes.
If he has been required by order under this section not to remain in India, meet from any resources at his disposal the cost of his removal. Okay.
My lord,
Read the second part. And of his maintenance therein pending such removal. So he'll have to pay the cost. He'll be provided with the facilities,
my lord.
but the cost he'll have to pay.
My lord, now,
So therefore, we are repeatedly asking you this question.
my lord, with that extent, if a DFN cannot
Suppose-
afford it,
Suppose at a humanitarian aspect, the government says, no, you please come, you take the treatment also. No difficulty. But can it be imposed as a matter of right?
but on humanitarian ground,
You can always make an application. They'll consider you case to case basis because cancer is a very serious disease.
my lord,
It requires specialized treatment
My lord.
where it's available only in specialized institutions
my lord,
where the expense may be higher. You can always make an application, Mr. Mojumdar and Mr. Chaudhary. Definitely will give a more humanitarian look into it. But taking one extreme example, can it be made as a matter of right in general to be applicable to all?
my lord, what I am trying to submit is that on humanitarian grounds, this card to be provided because case by case basis, without a direction from this honorable court,
Yep.
they might not be given this right.
No, so you always can make an application that, see, I am a foreigner, non-citizen, no doubt. But circumstances such, I am compelled to live here. I'm suffering from this one. Please take a humanitarian approach. I think in the government of India and the state of Assam is their hurt is broad enough to accommodate these situations. This country does not deny anybody in general. But To take an extreme example, then make it as a matter of right for everybody across the board. I think maybe you'll have to submit further on that.
In that case, there might not be uniformity, my lord. But
Hmm.
if it is a given, if these cards are provided to them, then there would be. an
No, once a card is provided, you are across the board, everybody will be eligible, everybody will, it will be applicable.
This is the humble submission I am putting before your lordship.
Don't put it up. You have to put it before them, respondents. Because it is for them to frame orders in these things.
My lord.
And once they frame an order and the order is say something arbitrary, it's contrary to any law, you can always assail it. I think we'll have to balance everything.
My lord.
You are going in one direction. You have to balance it with the entitlements from the other direction and then arrive at a conclusion that you are applying a force of 100 kg, other side is applying a reverse force of 80 kg, you are entitled to 20 kg. It will be of something of that nature. But what you are presenting now is your entire force without balancing with the actual entitlement. Think over, tell us, we are with you.
My lord, whatever right the DFNs are entitled to, it need to be tested with the touchstone of right to live with inherent dignity, my lord.
Do you have similar provisions in any other country in a similar situation?
My lord,
So
the
that we can at least look into such provisions.
contracting parties.
Say, for example, where this similar problem can be there. One place we can think about, these huge migrations are going into USA from Mexico.
My lord.
This problem is there. What they are doing? Any idea? What is provided, what is not provided?
But there with my.
Why don't you make some more research? These things will be more persuasive.
My lord. I will.
Don't you think so? Or things of any other place. But it should be a forceful migration, not isolated cases, but in huge unprecedented numbers, where the effect will be the place where the migration is taking place, its entire economy, culture, their tradition, everything is likely to be changed.
My lord.
Migration of that magnitude. See what is provided,
Hello.
what is not provided will definitely take a cue out of it.
My lord, I was a part of immigration clinic at University of Texas at Austin. I was a student attorney. So I defended one client from Haiti. She was detained in Hutu detention center. And after she passed the credible fear interview,
Mr.
my lord,
Come on, that's the difficulty. Migrations of huge magnitude.
my lord,
This is what we are looking at. Individual migrations, isolated migrations are different. Suppose 1 or 2% has come. The government tomorrow may take a decision, yeah, give them everything. We are taking a very benevolent state. We are not looking into any law. They will give them everything. But same principle, can it be applied when lakhs and millions are involved?
in the US there are thousands of migrations. Almost every year, thousands of people are illegally immigrating.
Supreme Court is taking judicial notice of this problem. It's no longer something resident, or that something, the question is still open. If you want, we can read out some of the passages laid down by the Supreme Court.
With
So
regard,
this is accepted, that it is a huge one.
my lord,
Good. Something from that point of view,
with regard to US, my lord, I will submit before your lordship.
because there, although the magnitude is much, much less than what is happening there,
My lord,
the nature of migration may be to some extent same.
the right to livelihood is there, my lord. They are allowed to work.
Work. We have already allowed you that prayer.
Then, my lord, I should not be detained then.
We have already allowed that prayer.
If
Yeah.
you oblige.
Openly, we have expressed our view.
There are some technical problems, my lord.
That can be sorted out, no difficulty. Technical problems can easily be sorted out.
Like they have to
What? In doing so, how it is to be implemented, we are
with regard to my lord, right to livelihood,
all the four rights:
my lord.
livelihood, your residence, your health, education, food. These are the basic requirements.
My lord. There is a compilation of judgment I would like to get your lordship.
Don't bring those isolated migrations of Rajasthan,
Because the mostly Supreme Court judgments, my lord.
but based on those Rajasthan type migration.
These are largely on the principle, basically.
On this issue, is there any Supreme Court judgment?
On these issues, there is nothing.
That's
Because this
it.
jurisprudence has not developed yet.
So you have to develop your argument.
The all SCC paragraph, my lord, for your lordship's convenience.
But most of these judgments, difficulty is those broad-based principles are stated and restated. We all know about it.
My lord.
And we are agreeing with you on those principles. So you don't have to bring in more and more judgments to substantiate that. But to that extent, we are with you. Because frankly speaking, even I have done some research work. We have not found anything till now.
On these issues, my
It's,
lord,
it's not there. That's a difficulty.
probably has not been
Had it
deliberated.
been there, we would not have been asking you or prolonging it to this extent. We have straight away told you that this is what you are entitled.
I'm trying to go through everything, even this Stark's book your lordship recommended. But didn't find anything about this.
Stark's book was on aggression. On the topic aggression. The public international law.
It's not international law, it
I know.
involves everything.
It's a public intention, not the public. Some aggression.
Oxford, my lord, Oxford publication.
Yes, Mr. Mojumdar. You only say. How you want us to pass an order, how, in what manner these rights can be made available and it can be implemented.
As your lordship is indicating,
Hmm.
and this has got connection with the other question as to whether they fall in the homogeneous group of a foreigner entering a country.
No, no. Illegal migrant,
Yes, yes.
no doubt about that.
Yeah.
As an illegal migrant, whether it is one homogeneous group or it is difference within them migrants itself. This is one aspect. If it is homogeneous across the board, all the laws, all the principles will be equally applicable. If it is not homogeneous, we have to further explore what is the difference in the homogeneity. Its effect and its origin of the difference, and how to make it applicable.
Dis- distinguishing the.
You make an
rights.
elaborate submission, we'll hear it. And you also, if you find something in the meantime, please bring it to our notice.
Ma'am will address the court on this specific issue.
Yes, madam, what do you want to say?
Lordship, I'm preparing a note because if we see the present law also being amendment, there within if DFNs also, there is a segregation.
There is a
Segregation,
between,
like there is immunity for religious minority from East Pakistan who have migrated due to religious persecution. Even if they don't have documents also, Lordship, due to religious persecution, even the Immigration Expulsion Act 1950, that also provides for that. That foreigners will. So I'm making a note on that issue, Lordship, specifically on that issue. And even the passport entry into
you have
India.
any good books on this, any good book suggestion on these issues?
Commentary book, no, I have not found a good
No, no, not these law journals and all.
commentary.
No, no, good books on these events and incidents. Because one book is there, Politics of Migration. It's, I think, Maya Singh, Manju Singh. One book is there. There are some other books also on in these topics. Some internationally acclaimed and accepted books. Do you have any suggestions which books may throw some indication to these issues?
Then it's that immunity is being provided to even Christians. Then Garos who are mainly Christians, Hajongs, and the other.
See, and
category. Yes, Lordship.
why you can't draw a parallel with the Rohingyas? For this matter, Rohingyas are persecuted in their own land. They are from Burma,
Yes,
basically,
Lordship.
Myanmar.
Bringing upon
So
Rohingyas. over
there,
here.
these people are persecuted,
Lord.
I mean.
Yes,
Then they are crossing over.
yes, Lordship.
Some are crossed over to India, some are crossed over to Bangladesh.
Yes, Lordship.
So, although they may be of the same religion as that of this category of illegal migrants,
Yes, Lordship.
merely going by the religious similarity, the provisions may not be applicable because the
Yes.
circumstances in which the migration has taken
Definitely,
place
Lordship.
Is different.
It's
may be
different.
different.
Yes, Lordship.
What you are trying to point out, in fact,
I'm not stating about Rohingyas. I'm
no, you are not, but
Yes.
what you
understood.
are saying,
Yes,
based on the religious background, that there is persecution, you use that word persecution. I
yes,
heard it.
Lordship.
So this can be drawn parallel with the Rohingyas from Myanmar to some extent. Maybe we
Yes.
don't know to what extent, maybe to some extent. So for the other category of people, whether the principles and applicability as regards Rohingyas be straight away made applicable here? This is a very open question. Till now, I have not found anything.
Yes.
Yes, Lordship.
You have to build up your cases.
Yes, Lordship.
Make your argument.
Because passport and-
Even those judgments of Rajasthan was relied upon
Yes.
yesterday. And they also, in a particular given circumstance,
Yes,
those orders
Lordship.
were passed.
In most of the cases reported from 1950 onwards, my lord, either they come on a visa and the visa period expires,
Hmm.
then what is their position? In that context, it was decided.
Hmm.
But in a case of large scale
So
migration,
that's why we use the word homogeneity. If every migration is of homogeneous nature, then of course you can borrow any provision from any judgment and just
apply,
say, this is what is applicable. But if you are not, then what will happen?
yes. And my lord, if they are treated to be homogeneous, then some of the provisions of the, say, food security, those also will come in conflict, because everything there is not available to a person belonging to a,
That's what we,
so the distinction is
we
there.
are trying to examine in detail as to just come forward and tell us
My lord,
the provisions and this is what is applicable. That's all, we'll examine it.
from our side, we are also doing some research. Let us see to what extent we can find out.
Yes. We wanted to point out to something.
The immigration expulsion which gave provision,
That order, 1964 or something, yeah, that one.
Ah.
It's there. huh?
then maybe on the next day, I'm doing research also on that issue, Lordship.
Must be referring to,
116.
That 1950.
and that
Yes.
1950, page 116 of that book, I suppose.
Yes, yes.
We have noticed that. Continue tomorrow. We'll continue tomorrow.
Yes, Lordship.
Same order. if we do, And Mr. Awan, you did some good work, do some further good work. See what you can find out.
Trying my best.
All other matters deferred, some date will be given.
Our matter tomorrow at 2 o'clock, or as and when the
2 o'clock or before as and when, but not later than 2 o'clock.
whichever is applicable.
Yeah, but not later than 2 o'clock.
Yes.
Keep your blood.